Yeah, the judge, the only concern that I have is that retroactive child support is at issue. My understanding is there's temporary orders, so it's just retroactive child support. So my other concern is whether or not Mr. Lavender will be providing a bunch of documentations as far as receipts. And if that is the case, whether it would be more appropriate to actually set in person.
Okay, we're talking about receipts for credit against the retro, correct?
Yes. Yes.
And Mr. Lavender, how much documentation do you have, sir? Receipt wise.
I mean, going back to what 2021, receipts of receipts and then timing it with the time that I'm at home. Like I said, I didn't save receipts and put on there specifically like this was, for groceries or for like a $300.
Okay, here's the deal, Mr. Lavender. I only give credit for cash payments to the other party or major items or something that major items that are specific. I can't give, if you give somebody groceries, you give somebody clothing, that sort of thing, you give somebody diapers, I don't give credit for that. Retroactive child support. Child support is money that the other party would have been entitled to during that time frame to spend on anything they wanted. Now, if you can show that the mother requested you to buy that and you got the receipts for it, then yeah, I'll go with that. But if it's something you did out of the kindness of your own heart, trying to take care of your child, that's what parents do, then that's not the kind of thing I can give you credit for. The receipts I would be looking for are things like Cash App, Zelle, things like that, where you actually gave her money, or I actually have a former person in one of these cases that was making mom's Mercedes-Benz payments, okay? And he had the receipts for that. Guess what? He got credit because mom had the car, he made the payments. So if you got something along those lines, sir, that's fine. But if you got a lot of little receipts for day-to-day items, then like I said, the court normally doesn't give credit for that. But if you want to make an argument for why the court should, it's your right to do so, sir. But
okay, well then, I'm sorry, that'll cut out probably like 85–90% of the receipts then, because I know she's not going to support, like I've bought groceries or supported things in the household. So I already know that's the case. So there's just when we come back to another session, there'll just be a few things I may need to bring up, that were hard, contributable items that I've been stuck with, so to speak. And that'd be the only things I need to get figured out, as well as the fact that my gross is actually split between an hourly and an uplift that I have to support 2 different households worth of living because of my remote working situations. So now that I understand what is considered contributable, because like I can't just bring in like, well, a $300 Burlington coat factory bill, and that was like, oh, I bought a bunch of coats and shirts and shoes and things that day we went out shopping all together, or a $170 Red Robin bill. I can't bring that up, so I won't bring it up.
Okay, here's your sir. If you, again, a large one-time payment that was with both parties being present, that you saying that y'all went out together, you purchased those at the request of the mother and the child, and you spent $300, you got the receipts for that, I can give credit for. But I'm talking about if you went out and that evening bought $22 worth of stuff from HEB, no, that's not the kind of thing I'm looking at, all right?
Correct, I understand. And like I said, it's just like I said, I know I won't get credit for everything I have contributed to the household, because it would help if that was understood. But like I said, there's just a few things I may just need to bring up next time. So special session should not be necessary. Only for just I have the expenditures that it cost me to have the second part of living where I live at, which includes why I got the uplift, and then to show that where I actually spend those funds. I do have that documentation to kind of, go over that. Other than that, like everything else, I know I won't get credit for, and it'll just be my loss on
sir,
that
I'm still looking at a special setting, but I'm looking at a Zoom setting instead of a live setting. You got a lot of paper documents to enter the evidence, then y'all bring it in on a live date. But if you're looking at, if you just got some things to bring up and you think this can be done in about an hour, hour and a half, I can go ahead and hear you folks on November the 7th from 11:30 to 12:30 on a special setting on Zoom, where you're the only case I have that during that 1 hour time frame. Okay, so I'm looking at the 7th, special Zoom setting, 11:30 a.m. to 12:30 a.m. Is that a
That,
problem, sir?
no, sir, I can do that. I can do the 5th or the 7th, whichever one you need, whichever one
I
works.
got this, I'm looking at the 7th, because that's my special setting date. Ms. Garcia, will that date work?
Yes, sir.
All right then. And Ms. Gonzalez Taylor, since it sounds like it's only gonna be major items going forward, I think that probably will work at that 1 hour time frame and not have to come in during the live enforcement docket days, okay?
Yes, Judge, what time did you say?
10:30. I'm sorry, 11:30. I'm saying, sorry, 11:30 a.m. to 12:30 a.m. or 12:30 p.m. I'm sorry.
11:30 a.m. on November 7th.
Correct. And I'm getting ready to make the Zoom code before I even get out of here. And this
Yes.
is Lavender and Garcia. So I got the call number and everything. So I'm going to go ahead and make that right now.
Yes, and then Judge, could we admonish the parties that I will attach the Zoom instructions, which will include that any documents he wants to provide need to be provided in advance to Ms. Garcia and the state.
Okay, so sir, if anything you want to introduce, and ma'am, anything you have as evidence that you want to produce as evidence to as far as documentation is concerned, the state has a drop. Well, they got a Dropbox version of that when you have to send in that data, so they can have a copy of it before it was entered, and you'll have to also CC Ms. Garcia if you don't have her email or that information. I'll have the state once they get it CC her. But you would need to do that on or before the Friday before the 7th, which is the Friday, November the 1st. So anything you want to introduce as paper evidence or documentation evidence at that hearing, sir, you need to have to the state on or before the 1st day of November at 5 p.m. And I'll have the state will immediately send that out, CC the mom on that also, okay?
Yes, sir, I understand.
All right.
And then Judge, just one more issue. I'm sorry, before Ms. Garcia, his name is Matilda. We had her spelled differently. I'm just trying to confirm what her name is.
Matilde.
Okay.
All right. That's why I have all the original pleadings here. So yeah.
Yes, we just have it wrong on her when we named her.
Oh, you made it Matilda instead of Matilde. See it? Yeah. Okay. But now in the paperwork, it's great. It's right. All right. All right, guys. I'll see you on November the 7th, 11:30 a.m. Your own Zoom code, and we'll get you taken care of. All right.
Thank you.
Yes, sir.
Anything else, ma'am?
Judge, are you closing down Zoom so that I just send it to the parties?
In a couple of minutes. But if you need to speak to the parties, you can. I'm gonna be here about another 10 minutes while I get everything else set up. I need to do.
Then I'll just tell the parties, we'll send you the reset order. And as soon as Judge gives us a Zoom code, y'all have both already confirmed your email addresses with us?
Yes, sir. Yes, ma'am.
Mr. Lavender, you too?
It's in the email.
Well, I'll talk to you in the room.
All right, thank you, guys. Thank you very much. And we're all, well, I don't think I'll be recording this portion of it. I'm not, but I'm gonna go ahead and get that Zoom code and get it done. Thank you, everybody.
All right, thank you, Judge. All right, Tabitha, is Tabitha there? Can you help me move them back into a room with me?
The child in this matter was 4 years old in April of this year. So I asked the court for an opening to tell the court what the state's requesting as of today, whether or not this is a temporary or final order, and whether or not we're looking at any retroactive child support or just current child support, current cash medical, and current dental. Thank you.
Thank you, Your Honor. While the state would like a final, of course, I'm not sure that we'll get there today. The state's understanding of the parents' agreements is that they would be joint managing conservators of the child Mateo. Mother would be primary without any geographic restriction. Father, Mr. Lavender, would have the standard possession order in case parents can't agree to visitation. Mother will maintain both medical and dental for the child through her employer, with Mr. Lavender paying a combined medical and dental cost of $143. The contested issues, Your Honor, are with regard to current child support and retroactive support. The state actually has no problem, Your Honor, with either deferring both matters to further hearing or having the court order parties continue to do what they have been, which I believe testimony will be $850 per month since November of 2023. And while not in agreement as to that amount, it has been what has been shown by the parties And part of that'll be Ms. Garcia having Zelle receipts for which she was going to credit Mr. Lavender against the retroactive support judgment going back to the child's date of birth. However, it's the state's understanding that Mr. Lavender has a number of documents that he'd like to gather and bring to the court, not only on the retroactive matter, but as to his current employment. Based on the current employment, Your Honor, and what's just on paper, the state would have had him at the 1,610, even with one other child outside of this case. But just as early as last November, we had it at a more 1,080 amount. And I believe it would be best for this case, for all of the documentation to be present for the courts, this attorneys, and any ad litem the court sees fit to appoint, just because this is a unique set of facts in that parents were married and divorced prior to the birth of this child who has an AOP. And so there's a lot there, Your Honor, not just the usual.
Okay, well, I would like to say this is a unique circumstance, but it's nowhere near close. I probably had a couple dozen of these cases where a child was born after the marriage and had to do an AOP. So it's rare, but it's not totally rare. All right, folks. Okay, and I'm looking at possible ad litem. And I'm looking at giving Dad time to get his data together. And all right, folks. The state has explained that we have a child here that was born after y'all were divorced. There was some monies exchanged. Dad said he has more than what Mom's willing to give him credit for. So that obviously makes this sound like this is going to be a temporary hearing at best. And for right now, I'm not sure what amount I'm going to be ordering for child support. Based on the current circumstances, but the math's always the math. So I want to get some testimony from Dad, how he's paid, who pays him, whether or not he's some type of general contractor or a salaried employee, or what I'm looking at, and then to figure out what he's claiming that he's got as far as evidence about retro child support, so I can see how long this is going to take to get done, taken care of. Because sometimes, some banks are faster than others, and if he's got to go to a former employer, that's a possibility that it might slow things down, but let me find out what the circumstances are so we can figure out when we're going to come back and do the final. But for right now, for today, I would like to see about going ahead and setting up child support and current cash medical. But since I just learned that I had one more date available, one more slot available on the 10th of September, if I don't have to have an ad litem, we may can use that date and get everything done on that day and not to worry about a temporary order. But if I'm going to have to appoint an ad litem, which is a lawyer to represent the child, then they'll need some time to get up to speed, and I don't think they can get up to speed in less than right at 30 days. But let me find out what the parties are requesting and why they're requesting it. So let's go ahead and get some testimony and get this thing done.
The state calls Ms. Garcia. Ma'am, what is your legal name?
Matilda Garcia,
Who is the child in this case?
Mateo Lavender, Mateo Kim Lavender.
How are you related to Mateo?
I'm the mother,
Who is Mateo's father?
Michael Lavender.
Is it correct, ma'am, that both of you signed an acknowledgement of paternity for him, admitting your parents for Mateo?
Yes, ma'am.
Is it also correct that you and Mr. Lavender were married and divorced prior to Mateo's birth?
Yes, ma'am.
And in this case, ma'am, was I correct in telling the court that you and Mr. Lavender do have agreements for an order for Mateo, but the disagreed issues are current child support and retroactive or back child support?
Yes, we're today here for that.
Yes, ma'am. While we may not get to the retroactive support today, you are not saying that Mr. Lavender has never supported Mateo financially, correct?
He has given some payments through Zelle payments.
And based on your Zelle records, ma'am, specifically going back to 2001, which is the most or farthest out you could get at this time, it
Yes,
was a
ma'am.
total of $15,000 credit.
Yes, ma'am.
And in this case, ma'am, while you and Mr. Lavender only have the one biological child, is it fair to say that you are also in constant communication with his child in Georgia, just like he is in communication with the other child in your home?
Yes, ma'am.
Was I correct, ma'am, in stating to the court that you have Mateo's health and dental insurance both through your employer?
Yes, ma'am, since born.
And as far as the total monthly reimbursement from Mr. Lavender, that came out to 143 for both coverages.
Yes, ma'am.
And as far as the current child support, ma'am, you have recently been receiving $850 a month from Mr. Lavender. Is that correct?
Yes, ma'am, in the last couple of months. Yes, ma'am.
And while that may not have been an agreement between the two of you, it may have started with the amount of daycare's cost and then whatever else he could spare.
Yes, ma'am.
And as far as the temporary current amount that you're asking the court to grant, do you have a request?
No, ma'am, it's what's fair in the state of Texas.
And so, ma'am, prior to today's court date, you were aware of calculations by my office based on Mr. Lavender's income at different points in time. Would that be fair to say?
No, ma'am, there was never, we could never, the last two things that we had, they could never come up with an exact amount. I said until today that somebody gave me an amount.
Okay, so as far as what you were told today, was that amount $1,610?
I believe so, yes, ma'am.
And you understood that to be 17.5% of Mr. Lavender's income, as long as it didn't hit the max cap that Texas legislature lets us use for support.
I know it was 17%, but I don't know anything about the Texas cap.
Okay. And if I said, ma'am, that back in November, we would have calculated it to be something like 1,080, would
Mhm.
that surprise you? Would that disappoint you? Any reaction?
No reaction.
Okay. And ma'am, as far as there being additional documentation besides the Zelle of financial support Mr. Lavender would have provided to your family or household since your son was born, would you agree that there may be other things besides Zelle?
No, it's everything he's given me is through Zelle.
And so that's the direct cash. But as far as things paid for your home or vehicle, there may have been other things or direct things he paid, correct?
Yes, just the mutual, as I have paid for some stuff of his.
Yes, ma'am. Anything else, Ms. Garcia, you wanted the court to consider at this time for the purpose of temporary orders?
No, ma'am, that would be it.
Thank you, ma'am. Your Honor, I pass this witness.
All right, Ms. Garcia, we'll be back in just a moment. I'll let the state call your next witness, please.
Thank you, Your Honor. The state calls Michael Lavender. Sir, what is your full name?
Michael Kim Lavender.
And sir, were you able to hear my opening statement to the court?
Yes.
Was I correct in letting the court know what issues I believe you and Ms. Garcia have agreements on?
Yes, ma'am. I just want to clarify on that I'm wanting to see if the other contributions are contributions to be considered, not that I'm absolutely wanting to, have all that considered, so to speak, as we had discussed before. That's
Okay,
why
thank you,
we
sir.
need a little extra time.
I appreciate the clarification, sir. So it's just the child support, both current and retroactive or back, that you're needing the time to gather what you can and see what the court will consider at that final hearing?
I guess in those terms, yes.
Okay. And so, sir, you were aware of the amount of support calculated today based on either what you believe your employer reports, but you're saying it's not necessarily your correct earnings. Was that fair to say?
Yes, they are full earnings, but they are not spent as earnings.
And so, Mr. Lavender, what exactly do you do for a living?
I work in aerospace as a mechanical technician.
Who is your current employer?
Blue Origin.
How long have you worked for Blue Origin?
Going on 2.5 years.
And what amount or what is the rate at which they pay you?
My hourly rate is around, I think it's at 46, 58 or something like that at the change right now.
And sir, they consider you hourly, not salaried?
Hourly.
Okay, so that 46.58 is the amount per hour. How many hours per week do you work?
That amounts to, interestingly schedule, it still amounts to 40 hours a week.
And then, sir,
'Cause- I'm sorry, because it amounts to 80 hours per pay, a little, it could be around 80 or just above 80 per paycheck
how often are you paid?
biweekly.
And so in the month of August, you expect to see 2 checks.
Be 2 check, no, actually, because it's biweekly, I think there'll be 3 checks this month.
Okay, sir. So since you've been with the company for more than 2 years, you've seen roughly 26 in a year since they really do go every other.
Yeah, I guess it'd be 26 paychecks.
Okay. And then, sir, my colleague today let you know what amount she was using to calculate your support, correct?
Yes.
And so, sir, how did we get that $14,549.01 per month?
So one factor is the fact that there is an allotment that is that we have to use out of our own pay. That's what I pay for my own living. I pay my own utilities. I pay for my own gas. If I have to fly to and from work location, those expenses come from me. And also to, in the event of a situation where it's like, hey, we need a few things done, I've been able to pull a little bit of overtime here and there in order to help with things such as recently having to purchase a vehicle unexpectedly.
And Mr. Lavender, what city do you call home?
Killeen, Texas.
And what city do you report to for work?
That would be Van Horn, Texas.
What's the distance between your home and Van Horn?
From my house to Van Horn, one way amounts to about 500, and I want to say it's 567 miles by the time I pull in.
And sir, since you've been with Blue Origin, you've done your taxes, correct?
You know what? I've not done my taxes this year. Well, for last year. Last
Okay.
year I've got taxes, but this year I've not. I haven't finished filing those.
Okay. And so, sir, given the amount of expenses you incur just to do your job, when you did report for 22, was there anything specific about those expenses not being your employer's responsibility or as not really income since you paid it yourself?
Well, I didn't claim it as a non-income source, so it was all taxed as one lump because I am a full-time employee. And at the same time, I am using my personal vehicle and I am living out of a personal source of housing, not off of a company sourced stipend vehicle, such as them sponsoring a vehicle or transportation for me, or a sponsored housing, such as housing that they would provide and pull out of my paycheck. I'm paying for everything out of my own pocket.
And so, sir, if you took advantage of either sponsored vehicle or sponsored housing, would we see an amount less than the $14,549.01 per month?
Absolutely, because it would be deducted out of the paycheck before it even comes to me as net pay or gross pay.
Was there anything else, sir, you wanted the court to consider regarding your current income and how we calculated current support?
No, that's what I was kind of concerned about, because I understand it's just kind of a gray area how this is, and that's why I just was kind of requesting a little extra time to see, like, because the gross income, like I said, is not my true gross income because I do pay for everything out of my own pocket. And so that adds up pretty substantially. And then on top of that, there's just some other contributions that I was just concerned about that may not have been direct, child support payment per se, but I was just wanting to see if other contributions are considered contributions for the sake of the relationship of, providing with the child. And so that's all I was asking about earlier.
Okay, Mr. Lavender. And so, as far as supporting Mateo, what funds, if any, have you provided to Ms. Garcia, or what bills have you paid for her home, vehicle, etc., in 2024?
I mean, I've been steady with the 850, and that primarily takes care of the daycare cost plus extra, for the second part of the month. I've helped out, like we had an AC issue with the vehicle. I helped out with that. I'm not paid the full amount that I told her I was going to pay because it was just like all at once it came crashing down. There were things such as like this weekend is like one example out of maybe other examples. We go out to eat, we go shopping together, I pay for it, even though I know she pays, majority of everything else when it comes to the kids. But, we went grocery shopping a few times here and there. I'll pay for it. If we do something together, I pay for it. Typically, that's what I do. If we go on a vacation, if we need something, I can help pay for that, like on a spot sort of situation. So, but yeah, for this year, that's kind of what it boils. We've been kind of a little separated a little bit more this year than normal because of our situation, unfortunately.
And then, sir, with regard to the retroactive support part, the things you were wanting the court to consider potentially as contributions that would offset the 62,000 amount, after the mother gives you credit, it's a little under 50,000, but you were wanting the court to give you time to obtain those and bring it forward?
Yes, just to see if they are considerable. Just because, like I said, I have no legal counsel prior to this. Neither did I know that a retro was going to be requested the entire time. That was just kind of added today out of surprise.
Okay. And sir, do you have a time frame for how long you think it would take you to assemble what you need?
I mean, I'm hearing dates of September 10th. Right now that's just under a month time frame. That may be enough time. Like I said, I don't think it's going to do any good. So I can just get what I can together as best I can, consult with legal on my situation.
So you have the opportunity to go out and talk to an attorney if you wish also, but I was just looking for some time in September. The 10th, this was the first one that popped up at that last hearing. I'll ask Ms. Walker if they have something later in the month that's going to help also. And the question I would have is, you say you hadn't filed the 2023 taxes yet?
No, I have not.
All right, I know that are you doing them yourself, or you got an accountant to do it for you?
No, I have an accounting firm that does my taxes.
All right, then, they're going to have to be filed by October 15th in conformity with the extension.
Yeah, I filed for extension on anything that I haven't filed up to this point.
Okay, and I think the deadline is October 15th. Is that correct?
I believe so. Yes, sir.
All right, so I was thinking about that also, and I may that 2023 tax return might help. So I was looking at doing it sometime after October 15th, and that way it's a little bit longer, but but it's not going to make a great deal of difference. I'm looking at setting up a temporary order for temporary child support for the next couple of months, and then we can come back and nail everything else down after October 15th, and have you present get a copy of your 2023 tax return so we can take a look at that. Especially, and also I'd like to get a copy of your W-2, your W-2 and your last pay stub of 2023 that gives a year-to-date date on that sort of thing, and the breakdown of what it is. So you think you get all that, sir, and we can get something done and reset to the after the 15th of October?
Oh, I'm sorry. Yes. So not September, but you want to reset till after October 15th?
Unless you're gonna get your taxes done by then, I'd like to say I would like to for the state sends you a copy in your subpoena. They want your last 2 years of tax return, and obviously you and those folks. Just had another guy that we had to work around, but he went ahead and filed everything early, so that we didn't have to wait to the 15th. But I'm willing to wait to the 15th for you to get your taxes done, get that copy of your taxes, your W-2 that goes along with that, and your last pay stub from December 2023, because that will have the breakdown of where everything is going. Okay, so what categories? W-2s don't tell me that. They just give me your gross and your nets, for tax purposes. But your pay stub tells what the money is, what the money's for, and if it's a reimbursement or whether or not it's direct pay. All those things that are on your pay stub and not on your tax returns. But the tax returns, if you're writing certain things off as far as income is concerned, that could be helpful also. So, I'm looking at that date, sir, sometime, I'm looking at having you produce those in conformity with the papers that you were served with. Like I said, they asked for your bank records, they asked for your tax returns for 2 years. And I really would need to see those tax returns to help the court, navigate what we're gonna do here. So I am looking at some date after October 15th of 2024 to, for your final hearing. So that's the reason for it. Do you think you can get all that done by then, sir, for one of those days after October 25th? And that way we get a new order starting the first day of November.
Yes, sir. I'll do my best to try and get all that together. I'm just afraid that between now and then that things will continue to increase on my end. So I don't, you know,
Well,
I'm
we
real
can't increase too
skeptical.
much, sir. And the bottom line is I am going to go ahead and order some type of temporary child support starting the first day of September. So that's going to take care of the child support for that time frame, and then we'll deal with everything else prior to the everything up to now at that order, and give you credit for what you're entitled to, and try to figure out what the math is. And kind of sounds like y'all may have were y'all living together anytime during this time frame?
No, sir.
Okay. Oh, I'm sorry. You're not the witness now, ma'am, but that's the answer I
Oh.
needed. So, okay, thank you. But all right. So, well, all right. So there's no, y'all weren't living together, but I want to give you the opportunity to get any and all credit that you think that you're justly entitled to, sir. So is there anything else at this time, sir, that you want to tell the court? Or I'm sorry, I'll let Ms. Bungat bring you back and finish up your questioning. Thank you. You may proceed, Ms. Bungat.
Thank you, Your Honor. And then, Mr. Lavender, as far as the agreements that the two of you be joint managing conservators of Mateo, Ms. Garcia's primary, and you having the standard possession order in case y'all can't agree about visitation, all of that worked for you?
Yeah, I mean, we
Yes,
pretty
ma'am.
much have an open, you know, visitation setup, so to speak. I mean, I don't know how much more detail we'd need out of that based off of what my visitation rights are.
Again,
Okay,
sir,
and
like
yes,
I
sir.
said in my morning speech, any and all time y'all can agree, that's great. But in the future, if there's a dispute on what should happen, I want Christmas Day, no, I want Christmas Day, I want his birthday, I want, then say, nope, this is what the standard order says, that's what you got to go with. So that's always the fallback, sir.
Yes, sir, I understand.
And
All
then,
right.
Mr. Lavender, your employment doesn't offer health or dental comparable to what Ms. Garcia already has in place?
They do. We have talked about this before. We just opted to leave it on her since most of the medical is always going to fall under her Scott and White, along with her other child and herself. It would just be a double insurance thing, I guess you can say, for it to be added on the mine. And then on my end, it actually becomes pretty substantial because we're not married. And so instead of it being a standard rate of insurance, it's actually quite a bit higher because I'm basically adding just another kid to my policy. And then he's already got that policy. So that's, yeah, but I do have it available if it was needed to have that insurance policy on my end.
Okay, thank you, sir. Your Honor, I pass this witness.
All right, then, anything on redirect to Ms. Garcia, Ms. Bungat?
No, Your Honor.
All right, folks, I'm looking at resetting this matter to after Mr. Lavender gets his taxes done. I'm going to order him to send a copy of that, again, in conformity with the discovery that he was served with. So we need a copy of his tax returns, his W-2, and his and I'm throwing in that additional pay stub. I'm gonna give him an opportunity to pull together all the information showing what monies he alleged that were paid for the support of his children, and we'll get all that done. But I'm looking at a date after October 15th on this one. Ms. Walker, so what do you got after October 15th?
Your Honor, we have October 17th, October 31st.
All right, let's go with the 17th. Let's get it done before Halloween. So, folks, I'm looking at resetting this matter to October 17th. If you get the data long before then, sir, just go ahead and send it over to the state. But I want to go ahead and reset this matter to the 17th. And I'm thinking about a special setting on this one because this can get a little complicated. Let me see what I got as far as special settings after October 17th. Think about giving y'all a special setting, folks, and let y'all be the only hearing I have. That way we don't have to worry, y'all have to worry about waiting around. So let me see what I got after October 17th. I mean, October 15th. bring y'all in under a special setting date and give y'all a couple hours just in case. Let's see, I got October. All right. The 16th is a live docket, it's Tuesday. So, okay, so next one I'm going to have is Wednesday. Oh, that's land passes. Okay, that's all right. Looks like I don't have a special setting date. I've got two live dockets the next 2 weeks after the 15th, one in Bell County and one in Land Passes. So that's that. So let's go ahead and go with the 17th general docket, folks. I was trying to see about getting y'all a special setting, but I'll put y'all back on the general docket and we'll try to get this one accomplished on that day. So I'm gonna start with you, Mr. Lavender. Anything else you're requesting the court to do? And I'm gonna go to the state last because I'm looking at setting up a temporary order with temporary child support and temporary visitation and coming back and taking care of everything else. So, Mr. Lavender, any questions, anything else, sir, that you think I need to know at this time?
No, sir. I just need to have time to seek legal counsel, and also we need opportunity to talk between ourselves. That we really need to.
Okay, here's the deal, sir. She doesn't have to talk to you. She doesn't want to.
I know, I understand that, but I'm just saying,
And
the
if you have a lawyer,
opportunity.
she under no well, again, that's left up to her. But at this time, sir, obviously you're gonna have the time to go out and speak with counsel on what you want to try to do. So, other than that, sir, is there anything else?
No, sir. I'm sorry, Miss Victoria Bongat. I'm sorry, is that how you say your name? I'm sorry. She will be the one helping with the questions I have after this. Is that what I understand?
I'm sorry, what questions do you have after this, sir? I'm sorry, that's why.
No, I'm not talking about today, but I'm saying as far as further.
I'm not sure if she's
legal.
gonna be the attorney of record at the next hearing, but Ms. Mongat, are you gonna be, is it gonna be somebody else then?
Yes, Your Honor. This was in my caseload
welcome.
and I handled the temporary order.
All right, then, Ms. Mongat is gonna be the attorney on your case, sir. Yes, sir.
Okay, thank you.
All right, Ms. Garcia, and Ms. Mongat, the current child support is 1,800. Is what's that amount again?
So we actually had Mr. Lavender's income as over the cap, Your Honor. So with one child outside, it came to 1,610. But back in November, we had 1,080 based on his income at that point.
All right, but today you have it over the cap and it's the 1,610.
Yes, Your Honor.
Well, that's what I'm going to order going forward for the next 2 months. And if it turns out to be a wrong amount, we'll give them credit above and beyond that date, and we'll backdate it to give them credit toward any unpaid child support. So again, for right now, that'll work for the temporary child support. That's going to be due the 1st of September, the 1st of October. And if it turns out to be the final amount, that's fine. If it turns out to be less than the final amount, we'll fix that. If it turns out to be more than it should be ordered, then I can say I'll give them credit for that against any arrears that are owed. So, Ms. Garcia, any questions? I'm looking at naming you both temporary joint management service, giving you the right to decide domicile. For right now, that right, where you and the child can live is going to be. I'm going to make you stay either in Bell or contiguous counties because I don't want you moving away until we get this done. And at the final hearing, we'll see whether or not that's going to be the final order. And I'm going to go ahead and set up standard visitation, but you two can agree to something different. I'm going to go ahead and order you to maintain the health insurance. I'm going to go ahead and order the child support from him, the $1,600 amount to start the first day of September and do the first day of September and the first day of October. And I'm ordering you both back here on October 17th to see if we can finalize this. So, ma'am, and set up everything else, back child support, repayments, everything. Is there
Yes,
anything else you're asking? Do you have any questions at this time, ma'am?
No, sir.
All right, folks. Mr. Lavender, talk to your lawyer. See what you want to do, ma'am. You have the right to talk to your lawyer if you want to, but this is kind of simple. This is more an accounting thing than a lawyer thing. So, but we'll see. And but obviously, you both have the right to do legal counsel, and we'll reset for that date in October. So that'll give you almost 2 months to get that done if you want to. So, Ms. Mongat, anything else from the state?
Your Honor, parties will be excused as soon as we're done here, but I did want to remind them that since this is now a court order, payments need to go through the state, no more Zelle or other transfer, just to make sure we've got the records straight.
All right, so Mr. Lavender, a copy of the order will tell you where to send your funds. You can do it by check, you can do it by electronics. If you go to the Attorney General's website, they'll tell you how to make it. There's different sources to send in electronic payment. You just want to go straight up to a CVS pharmacy and use Western Union to do it. There's a special system for that. So, but it's all going to be explained in the order, but it all needs to go through the state disbursement unit in San Antonio, so you get proper credit going forward. So based on that, sir, do you have any other questions?
No, I'll just set it up the same way my current child support is set up through one of my
Same
bank
deal.
institutions.
Same deal. All right, thank you. All right, folks, see you in October. And again, we'll try to get this one finalized, and we're off the record. Thank you. And it had to reset because it was on the general docket, and was some contested issues as far as the income of the non-custodial party in this matter. Anyway, we reset to this day's date, allowed the Mr. Lavender the opportunity to present any evidence or anything as far as a spreadsheet or anything like that, is my understanding. But the deadline for that was the end of last month. My understanding, there's been nothing received by the state. So, and I've already informed the father that based on that, while he can present certain testimony that relies on whatever he has completed as far as that evidence at this time, but was not submitted timely, could not come into evidence in that form because it was not submitted timely, and the state nor the custodial party have had the opportunity to review that evidence and prepare for it. So at this time, I'm going to go ahead and swear both parties in. Let the state make an opening statement to tell the court what the state's requesting, and we do here today, but not the state's requesting this to be a final hearing. And then I'll go ahead and let the state call both parties as witnesses. They're here themselves, representing themselves, so they are pro se litigants. So, but at the end of the hearing, when the state makes their closing statement, I'll allow both of them to make a closing statement or closing argument if they wish to at that time. Again, any of the fact that they are their own legal reps in this matter. So at this time, first thing I'm going to do, I'm going to ask both parties to go ahead and raise your right hands so I can get you under oath. Okay. Do both of you solemnly swear or affirm the testimony you're going to give here today is the truth, the whole truth, and nothing but the truth, so help you?
Yes, sir.
Yes, sir.
All right, you're both officially under oath. I'm going to go ahead and let the state make their opening statement, and you can see what the state's going to try to do here today. And again, at the end of the hearing, after the testimony is done, I'll allow both of y'all to go ahead and make a closing statement and or argument, because that's what you're allowed to do as legal counsel for yourselves. Anyway, Ms. Mongat, opening to tell the court what the state's requesting we do here today. Thank you.
Thank you, Your Honor. The state is requesting that we do finalize this matter. The temporary order obtained in August was based on parties' agreements to be joint managing conservators of the child Mateo, for whom an acknowledgement of paternity was signed, based on the fact that the child was born after the parties had been divorced in 2011. Additionally, that order reflected the mother having a geographic restriction to Bell County and surrounding counties, father to have the standard possession order, non-disclosure wasn't pled for or otherwise requested, mother would maintain both health and dental insurance through her employment, while father paid the cash medical of $116 and cash dental of $27 per month beginning September 1st. It's the state's understanding that we reserve the issue of retroactive support based on the parties' differing opinions on it. I believe evidence will show that my colleague calculated a balance of $72,300 from 2020 through 2024, that October 17th hearing, and that mother was willing to give credit of $19,000, which would leave a balance of $53,300. And if granted without change, a requested repayment was calculated at $317. I believe testimony from Mr. Lavender will show that he has a good job and has had it for many years. Information provided to the state prior to the court's deadline of November 1 included the 2023 tax return and 2024 latest pay stub from October, both of which indicated that the temporary ordered support which did reflect it was the cap of 1,610, based on Mr. Lavender having one other minor child, would continue, Your Honor, just because the gross amounts are all in excess of the $12,200 dollar sum that would get us to the 9,200 we'd be multiplying against as net resource. And finally, Your Honor, the state is seeking an appropriate ruling regarding court costs. The state calls Ms. Garcia. Ma'am, what is your legal name?
Matilda Garcia Lavender.
And Ms. Lavender, who is the child in this case?
Mateo Lavender,
How old is Mateo?
4 years old.
Were you able to hear my opening statement, ma'am?
Yes, ma'am.
As far as the facts I provided to the court, were those accurate?
Yes, ma'am. To my knowledge.
Thank you, ma'am. And then as far as the temporary orders that are in place, were you requesting any changes based on a change in your family circumstances since August?
No, ma'am.
So you're comfortable with you and Mr. Lavender remaining joint managing conservators of Mateo, with you as primary, and that geographic restriction to Bell and surrounding counties?
That's fine.
And then as far as your son's health and dental, is it still being provided by you through your employer?
Yes, ma'am. It's mandated through my employer now. It's been through.
And then the amounts or the costs to you are still as calculated before?
Yes, ma'am.
And as far as Mr. Lavender's other children, you are aware that he does have one other minor child?
Yes, ma'am.
How old is that child, if you know?
I believe 17.
And then, ma'am, as far as Mr. Lavender's income, do you have any concrete knowledge about it that you've either observed or been told about by him directly?
And no, ma'am. Everything's been through the court.
Okay. And then, ma'am, with regard to the issue of retroactive or back child support, was
Yes,
the
ma'am.
information I provided what you were made aware of by my colleague on October 17th?
Yes, ma'am.
And so as far as credits, ma'am, the 19,000 is still what you're sticking with today?
Yes, ma'am.
You weren't seeking back dental or health support in addition to that child support amount, were you?
No, I just went with back pay, whatever the court assigned.
Okay. And then, ma'am, are you aware of Mr. Lavender ever serving in the military
No, ma'am.
or receiving any type of disability finding?
No, ma'am.
And as far as the information I received, ma'am, as far as Mr. Lavender's tax returns or pay stubs, were you also sent those at any point?
No, ma'am.
Is there anything else, Ms. Lavender, you're asking the court to do at this time?
No, ma'am.
Thank you, ma'am. Your Honor, I pass this witness.
All right, Mr. Lavender, at this time, do you have any questions of Ms. Lavender?
No, sir.
I'm sorry, I'm not, it's him asking you, ma'am. I'm sorry.
Oh,
Yes,
I'm sorry. Do I have any questions to Ms. Lavender?
Yes, you have any questions about it? And it's pretty much restricted to what she's testified to, sir, but do you have any questions of her at this time?
No, I just thought maybe she'd consider, some of the other items that I had listed to her to account for as far as credit based on other items, but I see that that's
Okay.
not going to be part of this.
All right, sir. Do you okay, so so it sounds like you're saying that you may have something above and beyond the $19,000 for support. Is that what you're trying to tell the court?
Yes, but I was told last time this is called the parenting. So
Let your attorney testify at the end of the hearing. If you want to tell the court that you feel like there's extra items that you should get credit for, I will allow you to testify to that on your own, sir. But again, but you'll have to be specific to what they are, and that way the court can determine whether or not they give you any extra credit above the 19,000 as requested. All right, then, sir. But that's your turn as a witness. Then, if you do not have any questions of Ms. Lavender, so I'll let the state go ahead and call you as a witness, and then at the end of the state's questions, sir, that's when you'll be allowed to add as needed. All right, thank you.
Thank you, Your Honor. The state calls Michael Lavender. Sir, what is your full name?
Michael Kim Lavender.
And sir, is it correct that you are Mateo's biological father?
Yes.
When was he born, sir?
And was it April of 2020?
And was I correct, sir, in telling the court that that was after you and Miss Lavender were formally divorced in 2011?
Yes.
And sir, as far as your other minor child, was Miss Garcia correct that your other minor child is currently 17?
Yes.
When does that child turn 18 and graduate from high school?
October 3rd of next year, he turns 18, and he was held back in elementary school, so he still has 2.5 years of school.
And then, sir, as far as the temporary orders, aside from the issue of retroactive support and a ruling on court costs, were you seeking any changes?
As far as, I'm sorry, as far as which part?
You're familiar with the temporary order from August, correct, Mr.
Yes.
Lavender?
Yes.
And so you and the mother were named joint managing conservators of Mateo.
Oh.
She's primary, able to decide where he lives within Bell or surrounding counties.
Yes, yes. Okay, that part, yes. Yes, no changes on that.
And then you have the standard possession order. Obviously, you and she can agree to anything.
Yes.
And as far as the health and dental, you're still comfortable maintaining, or sorry, having her maintain those while you pay the cash medical and cash dental amounts?
Yes.
And then, sir, as far as the current support amount, you did in fact provide the tax return and pay stubs to me, correct?
Yes, last hearing.
And sir, would you agree with my statement to the court that you do have a well-paying job and have had one for a long time at this point?
Yes, yes and no. I would say yes and no, but yes, I've always been well employed.
Okay, and what was the reason for the no part of it?
Because initially when the hearing started, my income was based off my current job, not with my previous employer of a little over 2.5 years ago that I was with that was making less. So a lot of the calculations had to get remade based on my income not being the same as it is right now for the last 4 years of requested back pay.
Okay. And sir, as far as your income, would you agree that as far as actual earnings, you earned more than 12,000 each month before anything was taken out?
Gross, yes.
Okay. Let's see. As far as the retroactive support, Mr. Lavender, you were able to hear Ms. Garcia's positions on my colleague's calculations and the amount of credit she's willing to give.
Yes.
Since Mateo was born, sir, have you and Miss Lavender ever lived together?
No.
Was there any point that Mateo primarily lived with you?
No.
And sir, what financial contributions, if any, did Miss Lavender receive since Mateo was born from you?
Mainly Zelle, and then just when I'm home, I'm around, so to speak, and just general household item groceries here and there, which I didn't keep receipts on, and just very variety of things. But nothing in conjunction with probably what she would be expecting for actual child support.
And sir, the home and around, that was just as you could provide it, nothing requested, no agreements.
No.
And then what was the reason for the Zelle transactions?
So the Zelle transactions were kind of sporadic before, and then you'll notice starting about November, they're pretty solid. I kind of, and I'm still in a very isolated grieving mode. I stepped away from the entire family after my dad's passing the same time I found out about this child support thing. And I've been trying to cope with a lot of stuff. So since I stepped completely away, mostly and isolated, I've just contributed through Zelle. And that's it.
And so again, was that voluntary or some agreement you all made to a certain amount and time frame for such transactions?
No formal agreement. Just made sure I covered the daycare costs fully, and I know her electric bill is high, and that covered her electric bill on both payments each month.
But both daycare and her electric bill, those were all on Zelle.
Yes, but not paying the actual bill, but yes, that was the intention for the amounts.
Okay. And sir, would you say that the Zelle part of it was the 19,000 she's giving credit for, or was it a different number that you had?
I can't really prove another number because like I said, I didn't keep receipts and other things prior to and any sort of contributions. I did ask for, things like repayment on, the accident she wrecked my vehicle on, and I didn't ask her for a penny, but I paid all the cost to get that done. I'm hoping is part of the 19,000. And some other stuff I've helped out with, with the family, such as rent and excavating equipment and all that other stuff. I also asked to consider, because it was still technically, if it could be paid back from our divorce, to consider all the amounts of monies that were taken from my personal account that she had access to as a joint account, so to speak.
Okay, sir. Here's this, sir. There's no way in any state of this country that I can go back behind that decree of divorce. Only thing I can deal with is what y'all have done since the birth of the child, okay?
Right.
All right, that's what I gotta look at. Sorry, thank you.
And so, sir, were there any major purchases since your son was born in April of 20?
As in for between us or just in general?
That you spent the money for, but Ms. Lavender and your son benefited in some way?
Not really. I mean, like I said, everything else has just been normal contributions. I mean, I might have dropped $3,000 for a vacation last year that we did that I paid for, but I can't really ask for that to be credited because, I mean, that was for the whole family. It's just items like that that I don't consider purchases, but benefiting to the family that are not being credited to myself.
Okay, sir. And then as far as the figures, were you asking that the court consider a different repayment plan if the full 53,000 amount is confirmed as due?
A different payment plan as in, sorry, like
So my
readjusting the
colleague
monthly
said, sir,
amount? I'm sorry.
my colleague had calculated, sir, 53,300 as the remaining balance after credit had been given. And if the court granted that judgment, she was suggesting repayment of 317. Knowing, sir, that your current support amount is 1,610, and then adding this to it, were you asking for any specific repayment or consideration?
I was just asking for reconsideration on the amount. I mean, I don't know. I thought me being around for the last couple of years would be contributable, and not a monetary thing. So,
And sir, having been in these dockets at least twice before, you were able to hear judge's speech as to how child support is calculated and what are the main factors we use to get the numbers.
yes, as long as it was considered that my job for the last 4 years is 4 different yearly gross incomes, and I think I provided that on my tax return with a summary of what I earned dating back to 2020.
Yes, sir. And so aside from just making sure we had the numbers right, you're not disputing how we get to multiplying your net by 17.5% actually comes to something higher than 1610, but the legislature says we're capped at that amount.
I believe that's the scenario.
Anything else, sir, you wanted the court to consider?
Yes, like I said, I just wanted to, present the fact that my gross income is not, I'm an hourly paid employee, and then I do get a uplift, which is solely for my living and travel expenses and things of that sort, and I do spend it, and that's what I was trying to gather, because I was advised, if I can present that, that would lower the gross ceiling in which I am capped under right now, to be considered, hopefully. So that's kind of where I'm at today. And I don't know if you've received any emails from myself. You know, I didn't send any of this stuff, but I did send an email back on 8/22 when I could not access the original documents because I was at work by the time they started coming through, and it would not allow me to pull it up on my phone or work computer. It did not have my personal on me. But I do have that stuff if I can email them to somebody so that y'all can pull it up and see what it is I'm trying to present.
Mr. Lavender, you've already testified to being hourly. Is that accurate, or actually are you considered salaried?
I'm not salaried. I am hourly.
What
If
amount do you earn per hour?
I am currently sitting at 40, I think it's 47.10 an hour. I think it's on my pay stub if you have it.
And then, sir, how many hours per week do you work?
Average of just over 80, 80 to 85. Once in a while, we'll have something that comes up where I end up doing a little bit more, but usually it's a flat 80 to 85 hours a week, or per pay period, sorry.
Okay, I'm about to say, is that 2 weeks, sir, not a week? Because if you're working 80 hours a week, you're rarely getting any time to sleep. So yeah.
Yeah. No, sir, I'm sorry. No, it's 80 hours per pay period. It amounts to average about 80 to 85 is what I do.
Okay.
Like I said, sometimes it's a little bit more.
All right, that's what you got. That's why Miss Mom got asked, and that's why I was getting ready to do the same thing. Because, like I said, that's a little high. All right, but again, now it's you get paid every 2 weeks or twice a month.
Every 2 weeks flat. So I could get a third paycheck in the month, which
Yeah.
does not include my my uplift benefits.
Believe me, sir, I do this every day, and believe me, I know that's why I asked the difference between every 2 weeks and twice a month, because it is you get 2 extra paychecks a year based on that, instead of what people who work who get paid twice a month instead of twice every 2 weeks. It's
Yes, sir.
2 extra paychecks. So thank you.
Yes,
Anyway, I'll let the state proceed. Thank you.
Thank you, Your Honor. And so, Mr. Lavender, based on that and the pay stub from October 5th, would you agree that for that pay period, you had current gross pay of $6,807.53?
Gross total, yes, that's including my uplift.
And then, sir, as far as year to date, based on that, it came out to $142,637.73.
Yes, including that includes everything.
And sir, your pay stub was actually a 2-page slip that included a breakdown as to all earnings, where you mentioned things like the benefits and holiday stuff, correct?
Yes, that should be on the pay stub.
And
And
sir,
I'm sorry if you see me looking the other way. I'm trying to pull up my my work profile as I'm talking to you so I can be accurate with my answers to you.
yes, sir. But based on just what is shown in the year-to-date amount, when they include all of those things like benefits and holiday, you'd agree that that number, 143,560.14, is higher than the gross pay amount we're just looking at, the 142,637.73.
I guess that's the extra payout for the little bit of vacation I've taken. I take it is what you're looking at.
Okay. And again, sir, the parts that you were not able to send in and what you've been referring to as uplift, how many people for your employer have that situation?
We all have the uplift. It's a use it or lose it benefit because of the remoteness of where we are at. So we are responsible for everything once we receive the uplift, which is our living, our food expenses, and transportation. So I am responsible for anything it takes me to drive back and forth to work and occupy my stay there. it's fully my responsibility. So we all receive that benefit as full-time employees.
And then, sir, as far as your 2023 tax return, was the employer for the 2024's pay stub also your employer in 2023, so it would have been included in there?
Yes.
And so, sir, as far as that, you'd agree that there were two different amounts within the 30-page tax return itself, correct? As far as income for you?
If I understand the question correctly, you're asking if my uplift and my hourly is taxed differently, or?
What I'm saying, sir, is on a normal 1040, you
Oh.
have an adjusted gross income.
Okay.
And in your paperwork, you have two different numbers shown in there. Agree, disagree?
Agree. Yes, I would agree, I believe, on that. It breaks it down two different ways.
And so on one such thing, sir, your 8879 adjusted gross income is listed as 154,254, correct?
On this year's 1040, no, last year, sorry.
Last year's 8879.
I believe if that's what you're looking at, then yes, that it's broke down my pay versus benefits, if that's what you're asking. I'm sorry.
Well, that form, that number versus the 1040 federal return summary and all the documents which say 164,341 as total income.
Yes, for last year, I believe is what you're referring to.
Correct, sir, because I don't believe you sent me anything for 2040 other than the pay stub.
Yes, that's the latest pay stub that was requested last hearing.
Do you have any other sources of income, sir?
No, ma'am.
And sir, at the beginning of the hearing, when I mentioned that if your gross each month is higher than 12,393.86, there wouldn't necessarily be a change to your support. Do you recall that?
Yes.
And so, sir, given your information on the tax returns, that means you would have had to earn 148,726.32 in a month. But the information from 2023 indicates you definitely earned more than that, correct?
Yes, I believe so. Yes, for 23.
And is there any reason 2024 and forward will be different?
It's based off of the work. 23, we had a lot of projects that were kicked off, and I just got involved with some extra overtime that I used, obviously to, I saved up to do things with the family, paid for the vacation that we did, intentionally to do some repairs around, the house and all that other stuff, which is, if I could take a little bit of opportunity for that, that's what comes about. But yeah, it was a pretty busy year of buildup.
And sir, have you ever served in the military?
No, ma'am.
Have you ever received any type of disability finding?
No, ma'am.
Thank you, sir. You're on right past this witness.
All right, Mr. Lavender, the point the state was trying to make, sir, even if they were to start taking things out, with anything that you were asking credit for, get you down below the gross amount that, because you're maxed out. Anybody makes more money than you do, they only have to look at what that net amount that the state was talking about as far as what your net amount is based on those circumstances. So the bottom line is, if you made $1 million last year, you would still have to pay the same amount of child support, sir, unless you can show that amount got down below that net amount that the state, or the gross amount that the state's using to calculate your child support, sir. Because again, under the family code, we're now allowed to go above a certain amount. So is there anything that you have right now that you can show that will prove that you would get down below that gross amount that the state's using, sir?
I believe so, because that would cut out around 3,700, almost $3,800 a month on my gross per month.
Yeah. Okay.
It would cut
Here's the
out.
deal, sir. Oh, here's the deal, sir. Okay, another thing is, Texas has its own version. We look at what your gross income is, sir. Anything else you got extra coming out for other items or something that's not there, that's not to be included. We only look at taking out what the government takes out for the government. The Social Security, the Medicare, and the income tax. So if you got something, sir, and say you believe you do, you need to present it right now to show the court that there's going to be a difference, sir. Because right now, everything I'm looking at, this seems to be the proper amount of child support that the state's calculated, sir. So what do you got?
I mean, okay, so total, it would cut out 45,000 of my yearly gross income, and that's because I do spend my uplift. And the only reason why I'm trying to make a point on it is because my living out there and my living at home, I'm basically paying for two different households. And then now I'm paying on top of this a child support. And so I'm just wanting it to be calculated that, look, this money is, I don't keep this money. Like, I use it to travel back and forth to work in order to obtain this job so that she can get this high-end child support. And so, that's just what I'm asking the courts to consider. The money that I get from my uplift, because I am hourly, and that uplift is given to me to be my own responsible person to maintain my work, travels, and stays, that I do spend the money between food, fuel, RV payment, insurance, my RV lot rent, and miscellaneous items and things that sort that require me to, have my job, buying my work boots, had to buy some work glasses, do some repairs on the RV. I take care of all that by myself. I don't qualify for any of the other programs from the company, such as rideshare or housing or um, whatever else that's there that would take that away. So I'm fully responsible for that. And that's all I just trying to figure out who I need to send this to so you all can pull it up. My credit card
Sure.
statements from
So
October.
nothing you've told me has met a criteria that I'm based on everything you said, that I'm going to be allowed to use that to reduce your income, sir. You use that to maintain your job. Everybody works for a living, uses their income to maintain their job. Okay, I have to use my income to go back and forth to work, so forth. So again, the family code allows me to look at certain things, and right now you haven't. I don't see anything that's going to allow me to do something different, Mr. Lavender. I wish you would, with your kind of money, you definitely could have hired an attorney, sir, but your attorney might be able to explain to you what we can and what we cannot do. But we're getting to the point, sir, that I'm just going to I'm getting ready to cut this off because, again, the state has what they have as far as your tax information is concerned, and they presented those calculations to the court. And right now, I don't see anything that's going to allow me to change those calculations around. And I haven't heard any testimony that's going to allow me to deviate from those guideline amounts. Again, sir, I know you're not a lawyer, but you're representing yourself at this time, so this is what we have to deal with. So, is there anything else, sir? Again, you didn't send it in on time, so I'm allowing you to give me a little testimony, but right now I haven't heard anything that you testified to that's going to let me do anything different. And
I mean, the only option I have, sir, is just to relocate myself in order to alleviate the cost, because my job is nearly 500 miles away from here. So, me being away, like me obtaining this job, I am away from Bell County. And that's why I'm having to pay for my living and my fuel expenses, which are pretty astronomical. And I understand this is not like a regular traveling job. Like, I have to drive nearly to El Paso every week. And then, everything stays the same. My house bills are continuing. My bills out there, they continue to obtain. It's not like I bring the RV home every week or anything like that. It stays out there. And things of that sort. So, I mean, unless I relocate myself and just move completely away in order to alleviate the cost and try to sustain this this child support amount that that we are going for one child, I just hopefully, I don't know if I need to hire an attorney is my thing. I mean, I know I'm not I'm representing myself, but I don't know if I'm being clued that I need to hire an attorney because they have a little bit more of understanding how to make this account for. But I was trying to go into this because I did not want, to drag this out, have her hire an attorney against me, and we just go through this whole thing. It's just, I just wanted to prove I am an hourly employee, and that my uplift that I get is not, it's a use it or lose it, and I do use it, and for it to be discounted out of my actual gross amount for, you know, my pay. That's all I was trying to figure out what I can do. But I mean, at this point, I just see that I just need to make adjustments in my living locations, in order to alleviate the cost that I'm dealing with, is what I'm starting to get at. And I believe everybody will be fine with that because, yeah, I mean, if I have to pay the child support, then I have to make it work, and I can't afford paying for both households, so to speak, and then trying to maintain the child support. Basically, I'm paying triple at what I see. You know, my household, that household plus the child support is being graded with that amount included in. Like, I just did not realize that I just don't see it as a part of my income, is all I'm saying. So I don't know if I need to hire an attorney and need to what's the word? Come back with my case. I mean, because it's pretty substantial. I mean, it's $45,000 a year in gross that could be wiped out from my actual gross because I do spend it. Actually, I spend more than that because it's costs are pretty expensive.
Mr. Lavender, I gotta stop you now, sir. Right now, I'm gonna go ahead and have to make a ruling, and you have the perfect right to de novo this matter, which means you can appeal this matter to the district court who's assigned this case to me. But you know, your math's gonna be your math, sir. And right now, you're trying to, you're telling me things. You're telling me something that the court at this point does not see or cannot confirm that there's any way that I cannot include that as part of your income. Okay, that's it. And I'm getting ready to make that ruling, sir. And if you wanted to de novo me to the district court this matter, you got so many days to do so, sir. And you probably need to hire an attorney. But attorneys are expensive, and but if you hire an attorney and they think you have a legitimate thing at this point, then it's fine. But right now, sir, it's not. I don't have that data before me. They'll allow me to do that, sir.
That's why I was asking, who do I send it to right now?
It's too late, sir. It's too late. Sorry, I gave you until that time frame. Mr. Lavender, it is now 12:15. I'm stopping all testimony, and I'm getting ready to go ahead and proceed. Because again, sir, I'm including it. All right, you got it. It's on your taxes. You got it, and I'm including it as part of your income, sir, to calculate your child support. And again, you're maxed out. You're saying it's going to knock it down below that amount, sir. That's fine, but right now, you're not below that amount, and that's the amount I'm looking at, sir. Anyway. So I guess again, sir, I gave you 15 minutes here, and right now you haven't met the legal requirements for me to do something differently. So I'm getting ready to just go ahead and make my closing, and I'm going to allow the mother to make a closing statement because I gave you so much time, sir. So at this time, I'm ending all testimony, and I'm going to go ahead and get ready to rule on this matter. I'm going to give the mother the final opportunity to tell the court anything else she thinks I need to know at this point, and then I'm going to go ahead and rule. Thank you. All right, Ms. Lavender, your turn. Like I say, Mr. Lavender has had the floor for the last 20 minutes. Is there anything else, ma'am, you need to add at this time? Or you
no, sir. Oh, no, sir. The only question I had is, he states that it's supposed to be deducted from his check. I did not get any type of full payments this last 2 months. So I just wanted to ask if it was supposed to be something deducted from his check, because I haven't received anything.
All right, ma'am, here's the deal. The state normally still sends out a wage withholding order, and I'm not sure how that's been set up in your case or not. But again, right now, this is not I can't answer questions. If you have a question along those lines, or either you have questions along those lines, you can get back with the state on that. But right now, the judge has got, again, that's administrative, and right now I'm getting ready to do the legal part of this. So is there anything else, ma'am, legally you're asking the court to do?
No, sir.
All right, Ms. Bungay, anything else, ma'am?
No, Your Honor. The state, I believe, has proved its case through the testimony and relief requested in the opening.
All right, then, Mr. Lavender. Unfortunately, like I said, you make a lot of money, sir, and those are the circumstances. That income comes to you. The state has shown that the monies that you receive are in the max, are what the state, what the court is allowed to look at, the amount of the court is allowed to look at, you have maxed that out. You are above that in income. So based on the court finding that you are above the maximum amount that I'm allowed to look at, I'm gonna go ahead and grant the child support amount that the state's requesting. I'm gonna go ahead and grant the cash medical and the dental repayment to the mom for her, and order her to maintain the health insurance and the dental insurance going forward. I'm going to go ahead and grant all aspects of the temporary order, keeping y'all both as joint managed conservators. I'm giving mom the right to decide domicile. That right is restricted to Bell and contiguous counties. I'm going to I'll waive court costs in this matter due to the fact that well, it's a brand new case, and I'll go ahead and do that just for the heck of it. I am gonna go ahead and reduce the judgment, the unpaid child support during the time frames as calculated, sir, and order repayment at the amount the state was requesting. And again, it's not that was 317.
Yes, Your Honor.
All right, repayment at 317. Sir, there's 6% interest on retroactive child support. That is a killer. So going forward, yeah, this is going to be here a while, but the circumstances are the circumstances. And the fact that, and we are taking into consideration that you do have another child, and that child will not emancipate. It doesn't sound like until the graduation from high school. And this is 2024, so it sounds like the child's graduating in 2027, sir.
I'm sorry, you cut out. Hello?
I'm sorry. Okay. Your oldest child is graduating from high school in 2027, sir.
Yes, I believe so. If he stays on track, yes.
All right, then. And once he graduates, then the child support would automatically go up, sir, based on the fact that you only have the one child. Now, if you get another child out there, then obviously you get to come back in. But for right now, I'm ordering child support at the 17.5%, giving you credit for the other child. And there is, under Texas law, an automatic uptick to the correct amount once you get that. You only have the one child remaining, so it will go up to 20%. But again, if you talk to a lawyer, they'll tell you how all that works. But at this time, I'm on record telling you, sir, you've got 10 days to follow the note of this court. Once the court signs the order, which gets before the district court, and you at that point, if you want, then you can do what you need to try to do to show that the amount should be a different amount. But you know, be prepared that it may change in the other direction. It is what it is. But anyway, based on what information I've received, sir, this is the only way. This is the only thing I can do. You are above the maximum amount, and I'm capping you at that amount, sir. So at this time, that's what the court's going to rule. Is there anything else I need to rule on specifically, Ms. Mongat?
No, Your Honor.
All right, Ms. Lavender, is anything else? I'm gonna come to you last, sir, because I'm gonna give you the last thing. Yes, Ms. Lavender, anything else you have a question about, ma'am?
No, sir.
All right, Mr. Lavender, what's your question, sir?
I just had two things. One, if I relocate outside of Bell County without, it's outside the 100-mile radius, how does that affect, other than the visitation, is there any other effect that would have on me as far as mandates from the court?
No, sir. The only thing it will, if you move, then her geo restriction would be lifted. She would no longer have to remain in between Bell and contiguous counties. So you need to take that into consideration. That is in place to make sure you have a relationship with your child and the mother remain in the area, so you can have that relationship with your child. If you change the dynamics of that, then yes, sir, that would be the effect on that. But other than that, that would have no other effect. Nothing else is automatic in this case, and nothing is automatic. If circumstances change, then you would have, let's say you change jobs and all of a sudden you're making 30% less, then you would have to come back in and show the update the court on that information. If mom changes something around, or the health insurance goes up substantially, then she would have to come back in and show that, so the court can make an update of those circumstances. What the courts do, sir, are take snapshots in time. And once that snapshot is taken, that is what the court order is until there is a new court order. Any other questions, Mr. Lavender?
No,
All right. So again,
I don't know. I can't, this is hard for me to absorb. I'm sorry.
Well, sir, again, I tell people all the time, if, you hear my morning, if you make that kind of money, that's what I've got to order. So that's just the way it runs, sir.
Yeah. I mean, I've been supporting her other child too, that he only receives $260 a month, and yet I'm being penalized for thousands a month. And
no, sir, you're not being penalized. You're paying child support as set forth by the Texas State Legislature based on what your earnings are, sir. So
I understand. I just wish that she would go after the other father the same way she comes after me for everything.
All right, Mr. Lavender, you're getting off track on me on that one. Anyway, Ms. Bongard, is there anything else, ma'am?
Not for the court, Your Honor. I just wanted to advise parents that this order will be coming to your emails today, likely in the next 2 hours, and failure to sign it doesn't mean that I can't submit it to the court. Likely I'll do that on Tuesday after Monday's holiday.
All right, folks, again, those are circumstances. And again, Mr. I know I may be talking above you a little bit, sir, but you do have that time frame to follow the no that I've already told you about. And but if you file late, if you do something and ask for a new trial or a motion for something along those lines, then that comes back to me. The de novo goes to the district court, who in your case is the 146 Judicial District Court of Bell County, Texas. If it comes back as a straight out motion for further orders, for motion for new trial, then that comes back to me. And again, I just said a lot of things are legal matters, and but they are what they are, sir. So I've given you the right to de novo, and you need and the clock is ticking on that. All right, everyone, I'm going off the record at this time. We'll prepare that order and send it out to you. Again, like she said, if you don't sign it, that doesn't stop it. That doesn't stop the process. You signing that order only says this is what the court ordered. It doesn't say that you agree to it. It just says this is what the order of the courts are at this point going forward, and it will be submitted to me for my review and signature. And and it will be done electronically, so you can expect that I will sign that sometime early next week. And at this time, we're going off the record, and both parties are excused. Thank you.
Thank you, sir. And you're good to leave the meeting.
All right. And you haven't received any emails from me by chance, Ms. Mengat?
Not before November 1st deadline, sir. Today I haven't checked just because that's our legal box.
Oh, no. So I was trying to say earlier, I sent an email to you on 8/22